forward or where? Which part?
It's in the introduction.
So, I got it. Yep.
Okay, so the PDF, if anyone is missing it, is in the folder for Passing the Buck Volume 2. So go ahead and open that, and we're going to follow along that way. And we're going to go ahead and start in the introduction area, but just scoot on down to, I think it's like the third page in the introduction, called The Smoldering Trail. Okay, so 14 years after the original events started, Jim became a consultant in this trust matter. An associate attorney, frustrated by the replacement co-trustees' stonewalling, sought Jim's notable trust expertise to resolve the matter and get the missing answers. This turned into a legal action, which led to the ouster of what turned out to be a textbook case of trust mismanagement and use of trust funds for personal gain. Jim then became trustee, but let Jim Thomas tell us in his own words. Okay, where it says CA, that's Charles Author, the author of this book, and then JT is Jim. Okay, it starts out with Charles asking, when you first heard about the trouble with this trust, was it an ongoing saga in the background of your life, or was it sudden? Where your associate called you, explained the situation, then asked you to become involved? JT, sudden call out of the blue. The attorney was a friend of mine in San Diego, someone with whom I had become acquainted during my years of professional practice. We were also personal friends. He called fairly often when he had estate planning questions. His expertise was real property law, but he had a fair number of estate planning clients also. CA, what persuaded you to take on this challenge? JT, I am at a stage where I am more intrigued by the challenge and the cause of a situation or trouble than anything else. This seemed quite different and fascinating. It seemed unfair that this nice lady client, who should be sleepless, anxious, etc., over her financial situation, especially when by everything we knew, she should have been quite comfortable. CA, explain what court appointed means. Did you have to be interviewed by the judge? Did you have to fill out paperwork? How long does the process take? JT, the court took jurisdiction because we had petitioned the court on behalf of the client to have the court force the co-trustee to provide the information he was supposed to provide under the terms of the trust. It typically takes about 30 to 45 days to be heard, to have the court hear what each side claims, and then the judge makes a decision. Because the recalcitrant co-trustee failed to appear in court, in our case, it took a little longer to resolve. When it became obvious that the missing co-trustee wasn't going to obey the court's order, we amended the petition, excuse me, and had him removed. The client asked that I be appointed to his place. In addition to the court paperwork, to get all of these changes approved and in order, the court required that I qualify for a bond from a private insurer, which I did. The court respected the wishes of the client and then appointed me as her co-trustee. In an emergency, a court will appoint a trustee in a day or two, but there needs to be an exceptionally good reason to rush the process. In a situation where there is a friendly replacement, the old trustee is usually happy to relinquish his duties to a new trustee. The process should take about 30 to 45 days. As soon as someone objects or causes problems, as in our case, it takes longer. Working diligently, it took 4 months to get the court to make the change in our matter. You should note that if the trust is well thought out, changes in trustees can be made without a court action. This is an area where a little thought and a few more sentences in the indenture can make all the difference. A trust should be a private and confidential document, and failing to provide for the orderly change of trustees is simply poor planning. CA, did you have any clues about what you were getting into? JT, I had no clue. We knew when the husband passed away, the client should have an estate somewhere in 7 figures, but we did not know the starting number, nor did we know that over half had been dribbled out to friends and acquaintances of the co-trustees without adequate security or documentation. Yikes. CA, in what condition were the records? Was this like putting together a puzzle? Do you like puzzles? I mean, I love puzzles, especially financial ones. The accounting records were actually in good condition when we got into them, but I think that meant to say JT is speaking at this point. I love puzzles, especially financial ones. The accounting records were actually in good condition when we got into them, but the legal records, including the operation of the trust, were in a mess, if they existed at all. For example, out of 18 boxes of records, we would need 1 canceled check, then follow the trail of the money after we discovered where it had been deposited. We spent many hours at the county recorder's offices looking for transactions and related documents, subpoenaing banks and other records, and gathering documents as part of the ensuing legal actions. We took depositions from the parties as well as conducted interviews of anyone who knew anything about the history of the trust. The laborious part was tracing funds from account to account, party to party, until we knew who ended up with the money and we could hold them accountable. CA, what happened to make you realize that something highly unusual was going on? JT, before we got the records, we went to the office of the co-trustee who had promised to give them to us. He did not show up, but his secretary did and confessed half the money was gone. Needless to say, none of us could breathe. In our wildest imagination, we couldn't have guessed that he had been that irresponsible. CA, how many times did you meet with the previous co-trustee? JT, I count it as a sign of some character on the co-trustee's part that he was embarrassed enough to never allow himself to be confronted by the client or himself. I've never met him. We did get a written statement in connection with our lawsuit against him, but that was it. We still do not know why he acted the way he did, and my guess is that he doesn't know either. CA, please explain how the trust indenture did not address the situation. JT, this is another case where the trust was actually okay, but the administration of it was lousy. The co-trustee was required to account to the client at least annually, but did not. Where the indenture failed was in providing for a successor trustee. There was no provision beyond the first 2 trustees as to what would happen if they failed, and they did. The first named trustee never served because of health problems, and the second served irresponsibly. The trust did not say what happened after that. CA, how can you sue people to recover money that the previous co-trustee had the authority to give away? JT, there was no authority for the co-trustee to make gifts, so the funds he passed out had to be loans or investments of some kind. Some of them had some documentation that they were supposed to be loans or investments, and some were just carried on the books of the trust as accounts receivable. If nothing else, there was what is called a common court at law that simply says, you got the money, you should pay me back now. That allegation is made as part of a complaint, which is the document that starts a lawsuit to collect the debt. CA, how long did it take for you to recover the assets, and what percentage of the trust had been liquidated? JT, we are still not completely done. So far, it has taken us 4 years. We have some assets we took as part of settlements, and those have various problems that take time to get past before they can be put into the trust. We also still have a legal action against an agent of the co-trustee for mismanagement of the assets in his care and control. This is another side of the administration problem. The trustee really needs to oversee and check on the people he hires, to be sure their responsibilities are correctly executed. CA. This has been enlightening. I thank you for your time, and I am sure our readers will appreciate the experiences you've passed on. JT, as you can see, I do enjoy being a trustee, and I am happy to share this experience in the hope that it may be helpful to others who are involved in the trust process system process. Okay, so now we're going to go to chapter 1, unless anyone has any questions about that. Okay. Chapter 1, The Art of Administration. As explained in the introduction, the key to the success of any trust is administration. This is a skill set gained by doing. Although business administration is taught in school, the test is implementation of the lessons and seeing the results of decisions. Communication becomes the baseline of administration. The use of words, the skill in writing, the report of events through minutes can win or lose a conflict. And although rarely needed, they become testimony in legal challenges, create or destroy relationships with beneficiaries, and can haunt you because of a thoughtless mistake for the rest of your life. Where and how trust documents are kept also becomes a matter of survival. Trustees may think filing is a routine, simple matter. Passing the task off to a humble file clerk, uninitiated in trust administration, may prove to be a disaster. Through simple ignorance or intention, this menial file clerk can do you in. If you need signed trust documents and suddenly cannot find them, the complications range from frustration to a loss of opportunities and funds. And to underscore how important organizing your papers are, a not so uncommon trick in the courtroom is when a lawyer leaves papers on a table and then becomes distracted. The opposing attorney messes up these essential documents. Because references and facts cannot be found, often the decision goes, unfortunately, to the attorney who took advantage. The watchful eye. The trust rises and falls on administration protocols. At least one member of the trust group needs to care enough to handle the paperwork properly, ensure signatures are in the right place, and see to completing documents. This can be anyone who has signed a privacy agreement and holds a position as an officer of the organization. In one trust group, one person manages these matters for several trusts. A sophisticated follow-up has been designed, and trustees, general managers, and executive secretaries become the recipients of constant reminders to ensure that matters remain in order and continue to flow. The demands of paperwork are intense. Nothing can slip through the cracks because the organization is about taking care of others. Handle correspondence professionally on suitable trust letterhead with signatures when necessary. The Board of Education. A board, Board of Trustee meetings should happen no less than twice a year. They provide the core of the education for trustees. Every time there is a meeting, members discover the broader purposes of the trust's long-range goals. The minutes taken at the meeting must be accurate. These are legal documents and can testify to substance of transaction, or they can get the trust into unending trouble. A novice cannot take care of the minutes. We devote a chapter to minutes. In the appendix 3, footnote 3, are a discussed agenda for a Board of Trustees meeting and sample minutes. We will go over the details later in this book. What is 3? Let's see. Oh, Appendix D, sample format 17. Okay, agreements equal cash flow. The contracts become integral to daily trust matters. If funds to pay high-end vendors or private contractors are not approved, there can be endless confusion and frustration. For every matter that needs a contract, be sure one of the members of the Board of Trustees puts one together. We know some of you doubt you can write a contract. Our answer to you is, sure you can. There is enough legal software around and you can figure it out. You do not have to run to a lawyer every time you need a contract. In our chapters about legal issues, we include a discussion of contracts. We also include examples of the Appendix G. People need to grow into the administration. You will find people to help you. You need contracts between trusts or other companies so services or management can be performed. You need contracts with people who work for the trust, such as general managers and executive secretaries. Caretakers to property need contracts as well as lease agreements if trust vehicles or rental property is used by beneficiaries as well as other companies. To ensure there is no question where money flows, detailed contracts form the bedrock of clarity. Inventory documentation. Inventory is another item that falls to the administrative staff. If there are expensive paintings and collectibles, have they been tagged, photographed, or logged into the trust? Does someone on the Board of Trustees know where they are? This is a perfect job for beneficiary training. Accounting. Accounting is part of the trust's administration. A trust with a monthly cash flow of about $5,000 takes 6 to 7 hours a month of accounting time. This includes bill payment, handling beneficiary payments, posting funds received, going to the bank to make deposits, and preparation of reports. Here again is a good position where a beneficiary might be able to work into a long-term position with the trust. The person in charge of bookkeeping will, in the long run, need to understand complex investments and thus can act as an advisor to the Board of Trustees. Choose accounting software that handles investment. Not all of it does. After funding the checking account, one of the trust members needs to take responsibility to get the financial reports handled. Because of transfer activity and complications of setting up new investment accounts, print standard financial reports such as profit and loss balance sheets monthly. When the trust begins opening an investment accounts or new investment accounts, this creates many changes and sometimes confusion among the board members. These reports ensure that all members are on the same page and act cohesively. The person keeping the books should be an account manager involved with trust management, such as the executive secretary or the general manager. The footnote for 6, which was talking about handling beneficiary payments, says, for the sake of legal clarity, we distinguish between the word distribution and the word disbursements. Distribution refers to the appropriation and division under authority of a court of the remainder of the estate of an intestate. Disbursements refers to money expended by an executor, guardian, trustee, etc. for the benefit of the estate or in connection with its administration. We also use the word distribution in its more common form, used in a standard dictionary. So the key to the success of any trust is proper administration. This is true of the common law trust because of the intricate certificate registration and the need to have Board of Trustees meetings that need minutes. The trustees watch over not only the family, beneficiaries, and business, but the family assets, including homes, automobiles, jewelry, and many other types of property, tangible and intangible, such as insurance policies, stocks, bonds, copyrights, patents, trademarks, and real estate. Family involvement broadens. A trait unique to the common law trust is to transform mere, quote, family matters, unquote, into true business interests. This restructuring works magic to bring a family together. The wife, who may have been just a homemaker or homeschooling the children, can now develop latent talents. As an active member of the board, she learns about the investments and possibly finds that she can deduct some of her household costs as business expenses. Both she and her husband may discover the common sense economy she has needed to make the family's income stretch in the last day of the month now comes in handy in the broader scope of the organization. Gradually, parents learn more effective ways to plan their family's future. Education of the heirs. Through involvement in trust management, the children, as heirs to the family fortune, become properly educated to prepare for their new roles in the trust. Now they are beneficiaries and have a stake in its success. Showing them how to create a deposit slip, pay the bills, or have them included in the Board of Trustees meetings can work wonders. As this happens, you will likely see a surge in their respect for themselves and others. Their willingness to, quote, pull their weight, unquote, with chores and other duties, to complete their schoolwork and ask for more. Being included contributes to their maturity, becoming worthy beneficiaries and potential trust officers. Education. Traditionally, a long-range financial planning concern of families now becomes a matter for the Board of Trustees. Educating family members in such subjects as accounting, finance, business administration, and law makes them contributing members to the trust group. This adds to the potential of expanding this family business. This level of planning requires parents to handle children appropriately to get them interested in the trust when they are young. Inviting them to the Board of Trustee meetings when parents feel it is appropriate sets children up for greater future participation. Herein lies the key to perpetuating wealth, developing the successor trustees and managers now. Okay, let me go back up to the footnote. It says, if your trust cash flow increase is based on a particular asset type, then the educational cost relating thereto may be deductible. Consult with the tax advisor. Okay, as a bonus, thanks to the tax advantages for all irrevocable trusts, the beneficiaries pay the taxes on their share of the beneficial distributions, reducing the liability of the trust. This means that profits taxable under other circumstances now pass through the trust to the beneficiaries. Further, as we mentioned in Volume 1, generous gifts taken as expenses are a deduction for the trust and reduces taxes. These funds can be put away in a savings account or invested for the college education of the beneficiaries. Okay. Anybody have anything that they want to ask? So basically, so far, they're just saying, as far as I can tell, that you really preparing yourself beforehand through the indenture and through picking your trustees and having these regular annual or biannual board meetings are very important to keeping everyone abreast to what's going on in the trust. And also getting your kids involved is also vital, because if you want this trust to go through generations, then you need to get them excited and get them involved as soon as possible and make it fun for them. Boom, boom, boom. Okay, where did I go? So text. Okay, sorry, I missed my place. I was like, okay, daily responsibilities. The grantor can be the driving force behind the trust, but needs administrative and sometimes moral and emotional support from the trustees, other officers, and family. They not only serve as his or her advisors, but shoulder some of the duties of managing the family. Many times, the grantor proves to be the problem. If he or she becomes involved, the grantor may still believe this is a personal pile of cash and forget he or she gave it away. Organizing a trust makes a significant amount of paperwork. An important amount of time is spent making trips to banks and other institutions. As the trust matures, the volume of paperwork drops to a routine and easily managed level. Also, this part of the administration should be handled mostly by the trust's executive secretary, who is in a unique position to keep proper procedures and to ensure trust documents are treated correctly. Should the executive secretary not be inclined to deal with all the details of the paperwork, he or she may delegate them to a secretary or secretarial service. An oath of privacy or confidentiality agreement needs to be signed. This individual or group can assemble or produce all necessary documents and deliver them for the executive secretary's review and signature. The board of trustees will most likely meet their monthly, the board of trustees will most likely meet either monthly, every 2 months, or quarterly during the first year, after which the frequency will either increase or decrease depending on the trust activity. It may meet as rarely as once a year if the activity level is low. An active board develops a strong camaraderie as its members interact with the grantor and get to know one another. As mentioned above, this cohesiveness is one of the greatest strengths of a family trust. People who support and rely on one another can be a force to deal with should any outside interests threaten to disrupt the smooth operation and regular cash flow of the trust. So I just want to mention something. This whole part about the executive secretary and being able to delegate it through maybe a secretarial service and making sure that you write a privacy agreement, this actually goes hand in hand with the law of agency and like how the agent of a trust can hire out third parties to basically help with a business. So I'm finding that a lot of these trustee positions actually go hand in hand with like just, building a business, because that's kind of what it is. Okay, training. In our collective experience, most trust services aid only the grantor to set up an irrevocable trust. Few training resources are available for other levels of administration, yet the proper application of administration procedures is vital to ensuring the grantor's support and relief from many of his or her duties. It is helpful if the trust members take courses in accounting and get exposed to legal issues. Although not the most pleasant task, sitting in a courtroom to listen to matters being discussed and debated before a judge can be an enlightening experience or exercise. As frightening as it might seem, trustees who are not lawyers do sometimes need to go before authorities to argue their cause. Although the fledgling trustee cannot imagine doing this with sufficient maturity in the position, enough knowledge, and ample support, you soon discover that as frightening as it sounds, it is doable. Miracles do happen. Here is an event that surprised many of us in the trust business. Although she had few assets, Mary put her own business into a common law trust. The business yielded a significant but minimum cash flow. Not in a position to do much with her trust, she opened one of the 2 checking accounts, and because of the vicissitudes of life, never got around to completing it. She could never settle down enough to grasp how the trust worked and exactly what was necessary so the trustees could work with her to build up the assets. A year later, she fell in love, not with just an average hardworking 9-to-5 person, but one who had substantial income and assets. He paid extraordinary taxes and became astounded at the tax benefits of a trust. He put his assets into the trust she started, adding his beneficiaries. This small trust blossomed. New trustees were added. After his assets were contributed to the corpus of the trust and the extensive trust documents completed, Mary signed a contract with a company in another state. This caused the situs of the trust to move. Luckily, there was a person in that state close to where she was located who could be one of the 2 trustees. The bank accounts needed to be changed to the new state. One of the trustees handled the trust administration, but being in a different state had limited ability to keep track of the details. Not organized enough to keep her papers straight, she kept what confused her in the original envelopes somewhere. Financial information was packed in various boxes anywhere. In this new environment, these lovers were hopelessly lost. They also had checks piling up under the names of the trust and could not deposit them, as the new bank account had not been set up. Yikes. Unpacking completed, some trust organization then took over. The first order of business was to get both trustees to the new location. After their arrival, 2 days and 12 hours later, the accounting was put in order, and methods and procedures were in place to go forward to the next level of trust business, and of course, open bank accounts. Leadership. The issue with administration is leadership. Who in the trust group is the strongest member? Who can set the tone and direction? It is most often the one who cares the most. Sometimes it is the one who is the most comfortable with deciding. At times, it is the one with the vision. If the board of trustees discovers all 3 qualities in one person, your trust is lucky. Most of the time, though, the trust lacks quality leadership for the following reasons. 1, the trustees are too afraid to take a stand. 2, the grantor may have a vision but no leadership qualities. 3, the overall tone and direction of the trust group is lacking because of inadequate communication. 4, the beneficiaries are not involved or squabble amongst themselves. 5, overall dysfunction in the family. 6, the dominant natural leader is shunned because others have, quote, issues with him or her. The knowledge, and 7, the knowledge of how to lead is lacking. To encourage a trust leader to find his or her way to the top, he or she needs enough education and support by other members to become one of the decision makers. Frequent trust meetings add notable force to getting members on the same page. Communication issues often get resolved and methods worked out. Do not be shy about having meetings. Sometimes there is a financial consideration. Since people need to be paid for their time, many issues remain unresolved. Hold meetings anyways. If funds are an issue, then postpone payment. If people are also trust certificate holders, they should have no problem waiting until the trust amasses enough funds for payment of services. Should there remain problems with leadership, then call in advisors, counselors, and experts to teach the board members so the trust can mature rapidly and benefit all the members. There is a need for focus, yet with ample motivation, setting up a trust is no more difficult than setting up any other business. Oh, look at that. All right. Anybody want to talk about that? What I just read? Have any questions? Concerns? Things you found interesting? Okay. Elle, you want to read the next chapter?
Dutiful Attention, Chapter 2. After settling a trust, the major focus becomes administration. It is always best to look before one leaps. So now is the time to become familiar with the skills and talents needed to handle a trust. Getting a trust turns the family into a business, conducted as one. The product is the children. The goal is a better life for all involved. In this capacity, the trust supports the beneficiaries. Of course, for tax purposes, a trust is a pass-through entity. Referring to a trust as a business, other than within the context of this discussion, blurs the lines of legal definitions. Do not use the term, quote-unquote, business when filling out forms. Use the term, quote-unquote, trust. Because the trustees are in the business of managing assets for the beneficiaries, the entire financial base needs careful planning, good documentation, and consistent performance. Sometimes people do not take seriously the long-range effects of a trust. As shown in Volume 1, they create the documents, sign them, and put them away until death settles the heirs. Perhaps. Okay, I had to make sure I read that right, sorry. Perhaps they use the would-be inheritance as a game or a torture, changing beneficiaries at will, keeping children at each other's throats, whoever conducts a business this way. The positions of executive secretary and general manager are ideal for family members. If there are no family members to fill these key positions, then choose those with the potential to become trustees. With the myriad intricate tasks involved, these people learn quickly the important formats for conducting trust business. Based on the experience of fully trained executive secretaries, skill levels in the following areas need to belong to either one member or several members of the Board of Trustees. Further, the executive secretary, as an officer of the trust, may have his or her assistant take care of the details listed. In a particular trust organization, a trustee's talent base may make him or her more qualified to handle certain routines than can the executive secretary. Not all tasks listed here must belong to any one member. For convenience, they are included under the heading of executive secretary. Quotes. Think of the term executive secretary, quotes, as a broad-based function rather than an individual. Those serious about putting together a sophisticated financial setup to support the family long into the future need familiarity with the following job descriptions. These outline the expectations of those entrusted with the welfare of your legacy. All of these responsibilities support a fully functioning common law trust. Although a statutory irrevocable trust does not have an executive secretary and perhaps not a general manager, the duties remain applicable to all trusts. Even if there is only one trustee to handle the myriad tasks, these are the responsibilities. Executive secretary. Skills. The most important feature of the executive secretary is to have time to handle trust documents properly. The executive secretary holds a key position. Without right documentation, the grantor may need to pay taxes, as there is no proof of a valid trust. The time needed to devote keeping the trust records in order and attending meetings can be anywhere from 3 hours a month to a full-time job, depending on the trust size. The less time needed to devote to the trust, the more difficult it is to focus on it. Therefore, set aside time at least once a month. Lack of attention to documentation causes a logjam. When needed, there may not be enough time to get paperwork ready. You need to type at least 40 words a minute. If you are not savvy with writing minutes, or you will not be the one who writes them, you may need to set the format and dictate the events that happen in the meeting to another who can type them. Also, a trustee can take this responsibility, but the executive secretary ensures their completion. It takes focus to track a draft copy, incorporate changes, complete the minutes, and get signatures. It is important to have a computer and be familiar with a word processing program. This means you know your way around the internet as well as know how to load software. It helps to know how to connect a printer and to take care of miscellaneous small matters about computer interface. On the internet, you may need to research various legalities or supply investments as an aid to the trustee. You need writing skills. You may not be able to write lengthy legal reports, but you need to be able to write a letter. With practice, the skill increases to write more complex information for the trust. Business experience is necessary, but not an absolute. If other members of the trust group are willing to teach the executive secretary, the minimal business experience of a couple of years is enough. Because of the responsibilities inherent in this position, the more experience, the better. Improper handling of trust documents can lead to legal and financial complications. Familiarity with at least 2 or 3 different kinds of businesses is helpful. Trust documents apply to many applications. The executive secretary gets involved in mail services, including shipping and receiving, business contracts, and sometimes accounting. He or she may interface with counties about transferring, buying and selling property, plus handling getting contracts completed, to mention only a few. Documents. There will be a need to create original documents. This is not the executive secretary's responsibility, but he or she often needs to find resources. This applies to buying legal software at office supply stores or on the internet, or finding free documents, often available on the internet. All acquired documents need editing to trust specifications. Most documents are applicable to partnerships, corporations, LLCs, and sole proprietorships. Therefore, it often becomes necessary to make critical changes to relieve any improper tax status that causes an undue tax burden to the trust or to the grantor. The documents created need to be clear to withstand scrutiny and to be in alignment with accepted legal principles. Remember, the duty of opposing attorneys is to find fault, to destroy your organization, to ensure that their side wins. There is no reason to give them any opportunities. Quote unquote, the devil is in the details. An old saying goes, let them have a devil of a time finding fault in your paperwork. Sometimes certification of documents is necessary when seen by financial institutions or government agencies. Create a certification stamp for the trust executive secretary. It needs to have on it the executive secretary's name and the trust name. So, if you take over from another executive secretary, the certification stamp needs to be recreated. Since it is the work of the trustees that need certification, an executive secretary must be part of the common law trust administration. The trustees cannot certify themselves. The same need for certification exists in statutory trusts. There is an effort to resolve it by using a notary. This becomes awkward, for how would a notary be able to authenticate trust documents he or she did not create or maintain? Further, a notary is not privy to the inner workings of a trust and is not familiar with the trustee's duties. The documents most often needed to transact business are in the original trust book and always remains in the trust book. This list applies to both common law trust and statutory trust. 1. First and last page of the trust indenture. 2. Trustee acceptances and resignations. 3. Banking minutes or documents. 4. Investment minutes. 5. Certification of trust. 6. IRS original notification of the employer identification number, EIN. Use of these documents is covered in later chapters. Recreate banking, investment minutes, and certification of trust when there are bank signature changes, since they need current dates and signatures. Create trustee acceptances and resignations only when a change of trustee occurs. The executive secretary is responsible to send and receive documents, even if addressed to the trustees. You need to know the paperwork's whereabouts. Only send documents if they need trustee signatures. Otherwise, always send copies with certification to third parties. The executive secretary needs to know where minutes and other documents are in the signing process. Complications arise when trustees live at a distance and contact is by mail. Document location is important. Not only does the executive secretary need to know where they are filed, but so do other trust officers. Keep original documents integral to the trust in the trust book. Other documents can be filed in a filing cabinet. Because the executive secretary position is often filled after the original trust books are created, follow formats for standard documents as originally set up. Trustee changes. The executive secretary is responsible to create the resignations for trustees, and this includes all the holding trusts. You need to create the acceptance of trust for new trustees, fee agreements, new banking minutes, and a certification of trust. And all those were 8, 9, 10, and 11 for footnotes. Meetings. The executive secretary needs to be sure that meetings happen. There should be no less than 2 meetings a year. Because a board of trustees meeting offers an intense learning experience and gets all members of the board on the same page, it is preferable to have at least 3 meetings a year. The executive secretary takes responsibility for setting the date and gathering the subjects for the draft agenda. It is then sent to the trustees, the grantor, and other people who take part in the Board of Trustees meeting. Ideally, the executive secretary calls members to make sure the meeting date is set by agreement and they can attend after it is set. There is a phone call or email to get an approximate date and a phone call or email closer to the meeting to ensure all invited will be present. If the meeting is by telephone, there may be a need to be a telephone relay to know who calls whom. If people travel to the meeting, the considerations for traffic and providing directions are the executive secretary's responsibility. If people come from out of town, make hotel and motel reservations. The trust pays for this expense. Correspondence. Often, the trustees become less involved in the trust than the executive secretary, and therefore correspondence becomes more your responsibility than theirs. Most of the time, trustees sign the letters. Correspondence can occur by email, fax, and letter. If correspondence is by email, be sure to get a printout of significant information for the file for future reference. Year-end updates. The executive secretary works with the trustees to ensure that all trusts have at least 1 minute every year. Because many details are often overlooked in the haste of doing business, the executive secretary audits all trust books once a year to make sure they are complete. This means going through the trust books to make sure signatures and documents are in place. There may be a few trust books or in some larger or older trusts, there may be hundreds. If properly kept, these become a rich source of family history. Legal. The executive secretary is not responsible for the legal matters of the trust. Yet, because he or she is involved in board of trustee meetings, there is a need to be aware of legal issues. Involvement with legal documents is likely, especially contracts that need to be created, typed, and updated. Independent and private contracts have an end date. When they expire, the Board of Trustees needs notice should the contracts require renegotiation. File legal documents in their proper place. Photocopying is the responsibility of the executive secretary. There are many issues that may come up involving current and past matters. The executive secretary may or may not get involved at this level. Although thoroughly the domain of the trustees, one of the greatest responsibilities that often falls on the executive secretary is getting signatures on an oath of privacy or some other non-disclosure document relevant to trust matters. All trustees, the grantor, and others involved in setting up the trust sign the original copy when the trust begins. People later introduced to the trust functions and paperwork need to sign a privacy document. All beneficiaries who attend a Board of Trustees meeting must sign it. The oath of privacy or other document used carries severe fines for violation. This discourages the chatty. For practice, board members need to correct one another when too much information is shared when non-trust members are present. Financial. Although this realm belongs to the trustees, when accountants do not remember to create the monthly, quarterly, or year-end financials, it will often be the executive secretary who notices. These documents must also be attached to the agenda at Board of Trustees meeting and be available in their most current form for review by them when needed. Financial correspondence is chiefly the responsibility of the trustees and accountants, but the executive secretary needs to be aware of current issues and be able to find relevant documents. There's a large issue about the signature powers at banks, brokerage firms, and other financial institutions. The executive secretary needs to have the proper documentations ready to know who signs what and where. For example, if there are 3 trustees, 2 of them may sign at one bank, but 2 different ones may sign on the trust brokerage firm account. Interface with beneficiaries. The secretary is involved in correspondence with beneficiaries, and if beneficiaries attend the Board of Trustees meeting, the executive secretary is the one who usually handles the contact. The executive secretary needs to be sure all asset holding trust documents are in alignment and the right beneficiaries are on the right trust. Trust capital units. The executive secretary is the one who should create the certificates of trust capital units and keep the trust capital unit register updated. Although the trustees may handle this, it is usually the executive secretary who adds, subtracts, and issues certificates. The general manager. All these listed duties can be handled by a general manager. If the executive secretary handles most of these tasks, then the general manager's role is suitable to his or her capacities and unique contributions to the trust group. One of the most valuable contributions to the trust group the general manager often makes is research into various ways to bring in a strong cash flow for the beneficiaries. When this responsibility becomes a central focus, it easily takes up to 30 hours a week. These duties include internet research of possible income-producing opportunities. Some of the common ways a trust makes money is through business partnerships in any of a wide variety of enterprises. Also, common investments such as mutual funds and stock portfolios sometimes prove to be profitable. Promissory notes often produce a cash flow. With a creative general manager, the sources of cash flow become unlimited. Uh-oh, wait a minute. Sorry, computer. Okay. The most common and accepted income, though, is from rental properties or buying and reselling property. Involved in this area of the trust business, the general manager often spends time visiting sites, reviewing leases, and handling the various issues and problems that arise. It is easy to see why these responsibilities listed for the executive secretary should not be an overall concern of an active general manager. The general manager often reviews financial reports. Since he or she contributes to a strong cash flow, it is important to have available funds for more investments. If the cash flow is slow, then the investments are postponed until more funds become available. The Board of Trustees needs to determine to what extent the general manager can commit trust funds. This depends on whether the general manager is also the settlor. In this case, there need to be lower limits on his or her authority to ensure there can be no question the general manager is not in control of the trust. The limit on discretionary power to spend is set forth in the minutes. In one established trust, the general manager had authority up to $100,000 because of the average amount of transactions happening on a daily basis. Once contract obligations or other business decisions required a greater commitment, it not only took another trustee to agree, but it took all three of them to sign documents, and the general manager could only advise. In smaller trusts, a limit of $1,000 to $5,000 is common. Trustees. The indenture has an extensive list of trustee responsibilities. While the general manager may bird dog investments, it is the trustees who make the deals. Their signatures are all paperwork to prove trust ownership. Trustees handle legal matters from contracts to court appearances, whether they hire a lawyer or not. The trustees handle any complications, first through meetings and correspondence, then with the protector via mediation or arbitration before taking action involving the courts. All banking documentation, opening and closing bank accounts, getting loans, and any matters that involve the transfer of funds from one account to another or from one entity to another are the responsibility of the trustees. Trustees handle all tax and licensing matters. They need to get the city, state, or county paperwork and fill out the correct business licenses or resale permits if these apply to the trust. Further, the trustees hire and terminate all other members of the trust group. A trustee can resign, but if he or she needs to be terminated, then the trust protector becomes involved. We have devoted an entire chapter to the trust protector, so we will not cover that information here. Trustee qualifications. Although we addressed some of the trustee qualifications in Volume 1, here is more information. Because the first trustees hired may be friends of the grantor, they may or may not have the needed qualifications when they initially accept the responsibilities. As the new trustees perform their duties, they naturally gain accounting knowledge and get a smattering of legal information. Trustees who do not gain experience, though, in time become quote-unquote dummy trustees and become inadequate to the task. Because of distractions from other commitments, even professionals may fail to get enough involved. As the trust grows, the trustees need to grow. They endanger the assets and beneficiaries because of their lack of follow-up and interest. If trustees have not gained control or moved the trust forward, the beneficiaries can demand an immediate payout of the total assets in the trust. If there is no functioning trust, there is no trust. Trustees who fail to rise to the inherent challenges of trust administration should resign. If they do not volunteer to leave, then the protector resolves the issue. Because of the legal complications resulting from inaction, Remove trustees for incompetence before the trust achieves significant financial status. In a statutory trust, George Bogart, a leading trust expert, has said, before the court will order removal, some cause usually must be shown why the trustee ought to be removed. The court will not interfere unless some beneficial end is thereby to be achieved. In some cases, it has been said that it is beyond the court's jurisdiction to do so. It is more likely there is no necessity to remove a trustee, but to hire one to aid with trust management as the assets have grown and need more expertise to manage them. What may initially appear as incompetence may be simply the trustee is over his or her head. Over time, a trustee grows into the position. The following list of qualifications is a guideline for hiring a new trustee. Those considered competent have 70 to 80% of these characteristics. We have divided them into two categories. First one, trustees without previous experience. Minimum education, high school graduate, or self-educated, enough to be convincing of his or her abilities. 30 years old or older. Those younger usually do not have enough experience in life to handle complex decisions. Communication ability. They have good language skills, enough to create letters and write reports, have a computer. With today's technology, it is a necessity to be up to date with other trust members. That includes internet savvy. This is necessary for research and to get relevant information. Email correspondence. In a fully functioning trust, keeping in touch with the trust group is imperative. Scanning capacity, both to send and receive trust documents. This is most often the best way. Have a fax machine or ready access to one. This is important when documents need to be signed quickly and returned. And then a minimum of 2 years bookkeeping or accounting experience. This is an ideal. If there is no bookkeeping background, then a willingness to learn is important. Any resistance on this subject proves detrimental to the trust. The trustee is not required to do the accounting, but needs to have a grasp of procedures. This includes reading an income and balance sheet. Needs to be able to read financial reports or be willing to learn. Not intimidated by legalities. Curiosity to learn is a healthy sign of a good trustee. Most people are afraid of courts and confrontation, but some will be willing to take on the challenges. With enough support, legal issues are handled easily. Few trusts become embroiled in controversy. A minimum of 5 years business experience. This proves to be one of the most significant factors. The more knowledgeable, the more valuable. This one factor improves the odds for older people who become trustees. Familiar with or involved with investments. This is nearly a must. If the trustees do not have experience in this area, then the grantor should. Connections in the financial world prove to be one of the most powerful allies of the cash flow, and thus provide distribution to beneficiaries. Availability. Preferably not locked into a 9-to-5 job. Trustees need to have flexibility. The trust cannot be a stepchild. Quotes. It must rank high on the trustees' list of priorities. Limited travel. Being frequently out of town does not help trust matters. Although travel is part of most people's lives, those who are hardly available cannot be trustees. If one trustee is out of town, then the other one must be near the trust location. Have read books about trusts or have some familiarity with them. This educational requirement should be constant. An informed trustee is a better trustee. Excellent credit rating. At least one trustee needs to have this qualification. The use of a credit card for the trust is imperative. Under the trustee's personal name and assigned to the trust improves the trustee's credit rating. Since the trustees are in control of the finances, payment of the card is not a problem Before activating the credit card for the trust, create minutes so the trust takes responsibility for the card. This card is only used for the trust. No personal purchases can appear on the card by any members of the group. No political affiliations that cause undue attention to the trust assets. Nothing can get a trust into trouble faster than politics. The grantor may get him or herself involved in protests and marches, but not the trustees. There can be no connection between the political stand of any members of the trust and the trust itself. This means there can be no financial connections regarding unpopular issues, and the trustees cannot show up at rallies. The next one, trustees with previous experience. Familiar with or have connections to various investment opportunities. This can be one of the most significant gains for a trust. 35 years or older, the emphasis needs to be on older. As long as the people are alert, they are to the advantage of the trust group. Minimum 3 years trustee experience. This is helpful, even if the experience is with a living trust. Working with a living trust should give the potential trustee an idea of the difference between what is part of the trust corpus and what is not in a trust corpus. What is not in a trust. I'm sorry about that. As well as the difference between a trust account and a personal account. Familiar with legal cases involving trusts, all experiences of this nature are excellent. Dealing with lawyers. Consider this an art form. Sorry, I lost my spot. Okay. Okay. Many have, because my cursor, it's the way it is. I have to manually do it instead of using my keyboard. Okay, so many have negative experiences in this realm, which makes such trustees even more savvy. Have been in a courtroom, even if all they did is sit and watch, or as clients sat next to their lawyer. This exposure is an advantage. Is familiar with financial institutions. Often a trustee needs to interface with banks and bankers. This is because of large transactions, wire transfers, and the need to set up different accounts. For trusts handling a significant cash flow, there may be certificates of deposit, money market accounts, as well as 2 or 3 checking accounts. Opening and closing bank accounts, depending on the trust, opening a bank account is a skill. The larger the initial deposit, the easier it is. Opening and closing financial accounts. Most large financial institutions are familiar with trusts of all kinds. Although complicated, involving many forms and information, accounts can be opened. Handling. Loans. Trustees can make secured loans if the assets are large enough. Mortgages. It is essential that trustees have established a good credit rating. Otherwise, getting mortgages is difficult. Investments. Some financial institutions will not open an account unless one of the trustees can prove he or she has dealt with investments. Beneficial disbursement. This is an area where most people have little experience. Although the grantor may hold this responsibility, the trustees are the ones who sign the checks. Manage disbursements to various beneficiaries. Unless the disbursement is a routine set amount, create minutes stating the reasons for the disbursement and how much of the funds received are to be given out. When other trusts are involved in receiving money, complicated formulas may be appropriate. Also, some of those receiving funds may not want to take them or want them given to others. Understands K-1s and 1041s. This is learned through on-the-job training. Unless the person has a strong accounting background, it is common to use a professional in this realm. The remaining qualifications are the same as they are for a trustee without experience. Installing a new trustee is different from when the grantor chooses the first trustee. Because this chapter focuses on the duties and responsibilities of each officer, we will not go into the formal hiring procedures for a new trustee now. This should give you enough information to feel confident regarding who should be a trustee and expectations about the performance of all the trust officers. Okay, let's see. Oh, that's the end of that chapter.
Wow, that was a lot.
It was.
So yeah, I'm gonna have to go back through that one and be taking notes. I was trying to do it as you were reading, but I was missing a lot, so I kind of stopped.
Sorry.
But no. It's fine. I got to get better at taking minutes. So it looks like the executive secretary has a lot on his or her plate, and just makes sure that things are moving along well. That person needs to have like really good organizational skills, really good filing skills, and just be on top of every single transaction that happens, because they look like they're kind of like the centerpiece, because they work with the trustees, they correspond with the beneficiaries, and they do the board of trustees, like they keep track of those meetings, and making sure that like everybody's in all the roles that are within the trust, that person is making sure that they're doing their job properly and that they're reporting to that executive secretary so she can or he can file everything appropriately and keep everything up to date. The general manager seems to be focusing more on the cash flow in the trust, any kind of financials and stuff. I guess they're more of a helpful department that the trustees can go to for the finances, possibly. I mean, the trustees and the executive secretary seem to have the major workload. And then the protector was mentioned, and they can kind of keep an eagle's eye on things to make sure that, if the trustees aren't doing their job, then they can come in and kind of help in a situation if they need to remove a trustee or not.
It's interesting. The executive secretary almost sounds like the CEO of the trust. I mean,
yeah,
like they're and maybe the agent, the top agent or something like that.
Well, yeah. Because, go ahead.
For the trust.
Yeah, because before it stated that the executive secretary can also hire out other agencies to help that position out. So it's almost like the agent hiring a third party to help the trust.
Interesting. I saw with the Friends, their employment, the Board of Regents of a university here, it was the executive secretary that signed the paperwork and seemed to be the authority figure for the board. So it's like that's pretty high office, I guess,
Yeah.
And they better know what they're doing. And they take I think as far as liability, I don't know who would have the liability, the trustees or the executive secretary, you know?
Yeah, I would think it would be the trustees would have more liability. To me, it seems like it would be like the executive secretary for the CEO, because executive secretary is kind of wrangling everything together and making sure that everything is in order, where the CEO, or AKA the trustees, are the ones kind of pushing the paperwork and, investing, and they're the ones that are kind of keeping track of the taxing, the licenses, the permits, the bookkeeping, the accounting, the financial reports, getting loans, getting the bank accounts. But the executive secretary is the one in the back making sure that everything's done properly and everything, all the T's are crossed and the I's are dotted. But I don't think that they really have that much liability, as long as, they're doing what the trustees ask them to do.
I guess to execute, that word execute.
Yeah, exactly. They make sure that everything's executed properly.
I'm thinking, this is Joe, that she or he, the executive secretary, has to sign that, what is it called, the non-disclosure. They're not allowed to talk about anything. So I think my thought is the liability will lie with them if they...
they don't do their job.
Yeah.
Liability.
Okay.
Yeah, absolutely. I mean, they absolutely have to do their job, but as long as they're doing what they're being told to do and keeping track of everything, they don't hold any, like, say an investment went bad, the executive secretary isn't going to be held liable for that. The trustee will.
Okay. And that's a paid position, I'm assuming.
Yeah, one would definitely
assume that.
Yeah, assume that. I mean,
that person's doing a lot of work.
Exactly. Let's see.
Didn't quite understand the role of the protector, and if that was
was not expanded upon. That was basically just touched on, because they had said that if a trustee isn't doing their job properly, the protector can come in and basically remove that trustee. Like if they're doing things in bad faith and trying to do things to enhance, like with the example of that guy in the beginning where Charles was interviewing JT, they didn't have a protector in place, so they kind of had to go through court. And he was saying that they did not write the indenture in such a way to make it easy for them to remove a bad trustee. So, which is why they had to go through court to do it. Where had a protector been installed, they could have done that without having the court involved.
Sounds like a guardian angel, like that,
Yeah, exactly. They seem like, as long as you have a lot of safeguards, it's almost like checks and balances with these different positions, your trust should do quite well. It's when people are trying to manage a trust on a minimum budget is where, things might get a little hairy. And, you're trying to do everything yourself. Yeah, I definitely want to go back later and take some notes on that chapter. Anybody else have anything they want to talk about from that chapter?
It sounds like that in this chapter that you have to have, I mean, the trust has to be pretty big. I mean, it's making money or something where they're putting
Yeah,
in the corpus, you know what I mean?
Yeah, they said in the first book that you have to have like a minimum of at least $250,000. I mean, into a trust that's going to produce more money. You could create a trust that just kind of protects current assets, but if you want to build that trust into something that produces income, you need money to make money. And that's when, getting the executive secretary, getting the trustees, getting a protector, that's where that is vital. When you have a large funded trust where you want to grow it, it's vital to have all of those people in place.
I think if you went to a bank and you said you wanted to set up a trust with wealth management, they're looking up in the $1 million to $2 million minimum for that kind of thing. I mean, to be using their services,
Yeah. Which is, I mean, it's, if one can afford it, you don't necessarily have to hire somebody like a bank, because banks, they don't really have any vested interest. So they will do the basic minimum work for your trust, where if you get people that don't necessarily have the experience, but you hire, say, a lawyer to come in to train, to give kind of a class, or you pay for a class for accounting, like they were saying, taking an accounting class, bookkeeping class, in educating your trustees that way, then that would be very beneficial. It'll definitely be less costly than hiring, some big law firm to kind of take over.
And of course, everything gets nailed down with a contract. So they were talking contracts a lot. You have to have things spelled out in a contract. So that law of contracts comes in here,
Yeah.
Define the duties and responsibilities.
Well, the main contract the grantor really needs to focus on is that indenture trust. The indenture is vital, and you really have to think about every single scenario that might come down the pipeline later on, and have a fail-safe written in there, so that way when the grantor is gone, that the trustees have at least a map to know, okay, well, they wanted me to do it this way if this happened. But the contracts that they're talking about were more like, if you're trying to build the trust's business aspect of it and trying to get more money by, taking out loan, like allowing people to loan money from the trust to make money off the trust, or loan assets or whatever, that definitely needs to have a contract written up. And like with all of these things, if you are ever not really knowledgeable or you're feeling a little weary, like I would just write something up and then take it to pay someone a couple of hours to look over the trust indenture and get their opinion and see if they're missing anything. The same with like banking or something that a lawyer would know, just get them, do like an hourly consultation with them, show them what you put together and say, hey, do you see any holes in this? Okay. Nobody else has anything?
If you create a trust and you have a trustee who's acting on your behalf, and let's just say like an irrevocable trust, where you're no longer responsible for any of the assets. So, and you've assigned beneficiaries, let's just say your nieces and nephew, then what happens? How do you get any benefits from that trust? Does anybody know?
Private nobody, you want to speak on this?
Could you repeat that question again?
Sure. So let's just say I'm the person who's going to create a trust. And I have two niece and nephew I'm going to create as a beneficiary for the trust. And I say I assign Dawn as the trustee. Then I, myself, is no longer responsible for any of the assets within that trust. And so how do I get any benefits out of that trust? Let's just say it's an irrevocable trust.
Okay, when you set up the trust, you're granting a benefit to another. Why are you looking for benefit out of it? It's like when you set up what we're talking about now as family trust. Okay, and say you said you had two nieces that you want to benefit. Okay, so you're looking for their future benefit. Now, the benefit that comes to you perhaps would be tax benefits with regards to the funds that you grant to the trust on behalf of the beneficiaries. You would not be tagged with say for instance, you had $1 million.
Let me back up for a second. Let's just say I have a 401k and it's got well over 250,000 in there. And then I've got real estate property. I put those two in the trust. So my retirement 401k is now sitting with the beneficiary, but that's my retirement. So how do you see what I'm saying? Like, how do I get benefits out of it if I'm still living until then? Do I just not include my 401k? Do I not, or what's the protocol on that?
Okay, first of all, the 401k was supposed to be for your benefit in your senior years. So I don't think you will want to grant that to your nieces unless you were to pass. And I think you would need, for that particular situation where you're talking about property and the 401, I don't think they should be in the same trust, because the property, I don't know what you're doing with it, whether it's for income or it's just for shelter. Each of these things have to be thought out and designed specifically to the intent of the grantor, which would be you. So you would have to determine and map out what you want done with these assets, whether for your benefits, because take, for instance, if
right, I understand the well thought piece of it, but then if those are the pieces of assets that I want to protect, what would you say would be the best trust to go with then, if it's not the irrevocable trust?
Well, I don't know offhand, based on the strategy that you want to employ. and that, like we in the last reading we had, we must have read over about 20 different types of trust. And I'm not that fluid with trust overall, but each trust has a specific application. So you would have to look over the types of trusts that are out there, statutory or non-statutory. And mostly what we're doing here is common law, which is non-statutory, and determine which vehicle is best for your application. So it's not a general answer that can be given without knowing those factors ahead of time. So I don't want to give an answer that could mislead.
Okay, that's fair. Thanks.
Can I make a suggestion?
Can I make a comment on that?
Sure.
I spoke to a gentleman the other day who's extremely wealthy, and I had just asked him if he did trust, and I asked him the same question: how does he benefit? He told me, he didn't tell me which kind of trust it was, but he says, I set up a trust, and the beneficiaries go to a different trust, which is a living trust, and he is the beneficiary of that trust.
That's actually what I actually had the very same question with a friend of mine who did the same thing. His mom set up a irrevocable trust. She set up a revocable trust for him, and they both are, I think, trustees for one another. Yes.
So is the beneficiary of the first trust a trust?
Yes, a trust, and
Okay.
they both are beneficiaries of each other's trust.
Okay, so yeah, I think you might have just answered your own question.
So I wasn't sure if that was. I mean, you kind of said the same thing, which is what I was thinking. But I wanted to see if other people had the same answer.
Yeah, because I didn't know. Because if you have assets and you want to protect them, but you still need to make the cash flow from them, that was my question, and that's what he said to me. He says that's how we set it up, and he's an extremely wealthy gentleman. So I just wanted to kind of get an idea. I am not versed in this stuff at all, so here's my journey.
It sounded like they have two trusts going on. One of them where his children are his beneficiary, and then he's a beneficiary of the other trust.
Now that could be a problem because generally speaking, in certain capacities, especially dealing with family, being trustees for each other could be problematic if a legal issue was to arise. You should be at least one step removed from the trustee. And but overall, the concept is there, and many of the wealthy use trust that way that can go 5 and 6 levels deep. Trust within trust within trust within trust. That's common amongst the elite. So yes, that is a strategy. But as far as the trustee for each trust, and especially dealing with family members, that could prove problematic, especially when it comes times for disbursements. But other than that, theory or the concept is there.
I agree. I think there is a liability there for sure. I think that that's why it'd be wiser to probably have a board of trustee.
Yes. Yeah. At least some outside of the family for the sake of, fairness. And we read in the first book that that's a key, crucial element to keep in mind for the trust to be solid. It's make sure those conflicts can be avoided. And being trustees for each other can create a conflict of interest.
Now, you could create a business trust, and then
That's what I was gonna suggest.
Yeah, and then your family trust can do business, financial business with the business trust somehow. I don't know how that would work and how you would make it work, but if you created a business,
You have the family trust create the business trust. The family trust is the creator. And so as creator, it can be beneficiary. The only thing is that you have to, it's good to have 1 to 2 unsigned trustees in there, and definitely have a protector that's not related. So that's what we're doing. And my husband will be general manager of the business trust. But this will be created by family trust, which was created by my father. My father makes the family trust business.
you're breaking up really bad.
And oh man, I'm sorry.
Corner of the house.
I'm sorry, the family trust creates the business trust. The business trust has a general manager and can have 1 to 2 arm's length or unrelated trustees. They're not related to the family trust, and they're not related to the general manager. The general manager receives compensation for his work through a contract that he has with the business trust. And because the family trust is a beneficiary because it was creator of the business trust, well, then it also can get obtain benefits. So the business trust ends up being a pass-through entity, which is the monetary, the funds just pass through it. You got to keep really good books, just like she said. If you've run a business before, you've had a corporation or any kind of a business, you know, the standard stuff for bookkeeping. It's the same thing with a trust. Your trustees can get paid. You can pay for your meetings. You can have, if you put a trust and you create a trust that has a piece of property in it, like a house, like the gentleman mentioned, you decide which trust can create that trust, you know, or you can just flat out make it. You can be the creator of it. You put the piece of property in it, and then you have another trustee with you, and you can manage it. And part of the contract or the indenture for the house is that you get to live in it and take care of it. And one of the beneficiaries can be anybody that you want. You know, that's not you if you want. It's up to you. And you do all that by agreement. You do all that by contract. Some people actually rent the house from the trust once they put it in there. And then that way, you know, they're paying a little bit of rent. And they also have part of their contract is that they're taking care of the property for the beneficiary until they pass and they get to live in it. But that's all worked out in the indenture. They maintain it, you know, the trust pays the taxes for it. The trust can pay the maintenance on it. And if you want to give the trust a couple $100 a month, you know, for using it, that's totally up to you how you work it out.
And that helps to protect against liability from the public with regards to people coming after you for the property. But if it's in the trust, you're not considered the owner thereof, but you still have control.
Right. So, you know, if you, I'm not, you know, any kind of a wealth manager, but if I had, you know, let's say $250,000 that I'm getting as a, you know, distribution from a 401k or whatever, you know, parse it out, put some for your beneficiaries in one trust, you know, put some in some of that trust for that other house, a house or property you're taking care of. Create a business trust to fund that.
Yeah,
I mean,
it's not common. It's not uncommon amongst the wealthy to have multiple trusts
it's
because
highly
each.
recommended. It's highly recommended. The thing is that keeping all your ducks in a row. But like I said, if you're good at bookkeeping, it's not a difficult thing. It's just like managing 5 or 6 different bank accounts. It's all it is. But you got to go through the legwork at the beginning, and you got to set up all of your indentures, which is essential, and have all your trustees. So that's why it's really good to go out and meet people, make good friends, be intentional, and invest in time, because you can find out some of the people that are really sharp with business, won't mind. And you know what I'm doing? I'm just asking people, will you help me set it up and, serve for a year? Because, their time is valuable. And a lot of people aren't sure what the commitment's involved in. So the more organized you are, and the less, what do you call it, wasteful it seems for them, because essentially they're essentially helping you. Another way that I'm working it out is I'm actually approaching people that are setting up their trusts. And I'm like, hey, if you serve for me, I'll serve for you. So we'll serve each other. And I've got several people doing that for me.
That's great. That's actually great. And you learn along the way.
You do, and you just listen and you read a lot. You're going to make some mistakes. But hey, there comes a point where you can't just keep dipping your feet. You got to eventually just jump in the water, and start swimming. So, an irrevocable trust is not an end all. If it's not working out, make an agreement between the trustees and the beneficiaries and terminate the stupid thing. Make another one. You just can't amend it. It's irrevocable because it cannot be changed once the indenture exists, So once you put the assets in, they've got to be distributed. They can't, you can't just decide, okay, well, I changed my mind, You just can't do that. So, but it's locked tight because if it's structured properly, it really is a great protector, And some of these business trusts, you can go out and, you can do private contracts. You can do public contracts with them. I have a friend that.
Have you set up these trusts yourself, or do you use a estate planner or attorney or an accountant? Who do you use? What do you use as a reference?
Well, I started out with a very reputable template creator that I know the individual, and I paid him for his structure. I researched trust for a while. I did not want to pay an attorney because, first of all, I don't have the money. And number two, I didn't want any statutory language. And most attorneys, unless you really know their history, a lot of them are not really well versed in creating a completely private trust. I'm sure they're out there, but I'm sure the money I have can't buy those kinds of people. Typically, what I discovered is a lot of the trusts that are created by attorneys have a lot of statutory language, so you want to stay away from that. Because remember, your indenture creates how much of a wall of privacy you have. And then once the indenture is expressed really well, your trustees just have to follow the rules. That's all. All they have to do is just do what you said. It's not, a big deal. Accountants, same thing. They're called certified public accountants for a reason. Unless you can find an accountant that's not public oriented. I think CPAs are trained to help you pay taxes. That's what they're trained for. So I wasn't interested. Yeah, I was not interested in. What I did was I kind of just hunkered down and just did a lot of reading and did a lot of research. The Art of Passing the Buck was really good, the Law of Agency, and then I just started looking for trusts that I felt expressed me. You know, you can tell. You could tell you some of these you read and you could say, well, that's a compromise there. That's an easy open door. And I wouldn't say that. So just start reading. Some of them are going to be free online, and you know that's the junk. But look at it anyways and just read it. And then there's going to come a point where you're going to have to make an investment. You know, I can give you a reference because the gentleman that wrote the trust that I'm using, I'm adapting it to me and to my needs. There are a couple of things in there that, you know, I wrote them a little different, so I did, and a couple of things that I wanted to add, and I did. But all in all, it's pretty inclusive. So I can give you the information for where I got it. One of the things he did was he studied trust for a while, and you know he's not an attorney. He doesn't want to be. He's not an accountant. He doesn't want to be, but he's navigated these waters for many years. I kind of just watched him and listened to him for a year. I became a part of his group and just looked at some of the documents he made, and was pretty impressed. So when he put it out, he said he studied lots of trusts because people would show him, oh yeah, you know, I've got a Loctite trust, you know, it's this and it's that, and he said, you know, would you be willing to let me read it? And how much did you pay for it? You know, $5,000, $10,000. He couldn't believe what people were paying $5,000 and $10,000 for. I mean, it's I think $500 or $1,000 is fair, but I think beyond that, I think it's overkill, you know. So
well, that's
how I ended up. That, you know, there's going to come a point where you're probably going to have to make a small investment, you know, unless you're really, you know, really good at putting this stuff together, which you can start like that. You know, I think The Art of Passing the Buck also gives you a pretty decent start. Weiss's handbook, I know a lot of people use a lot of the material he gives there. Have you seen Weiss's handbook?
yes.
So those are some ideas.
So yeah, if you don't mind sharing your reference with me, I would greatly appreciate it.
Sure.
And
is it Robert?
Yes, it is.
Me
Robert,
too.
go ahead and direct message me through Telegram so that I know it's you, and then I'll give you his information.
Are you the pairing goat mama?
Yeah, I am.
Okay. Let me DM you. Thank you.
Can I get in on that too? This is Joe.
Yeah,
I don't know your name.
You know, sure. You just direct message me, so I'll send you his link. You know,
Thank you so much.
I'll tell you what. You know, studying and reading, you know, has really helped me a lot. You know, this is not any different than starting a business. It really isn't, because the trust is just a contract. That's all it is. And like Private Nobody was saying, you know, you structure the contract based on what you want to get out of it. What's your end goal? You know, what do you want to achieve? So it's good to map it out and chart it out. And then that way you can see how many trusts and which one relates to which one. So, yeah, I have a friend that he puts all his vehicles in a separate trust. So he's got 3 cars. They're each in their own individual trust. And then that trust has a beneficiary, which is he calls it the mothership. Oh, God. So the beauty of using these layers is if you decide to do a business trust, for example, and then you have your vehicles in another trust, but the business needs to use your other vehicle. The business, which is the one that's probably making most of the money, can actually lease that vehicle from the other trust. You see? So your business pays a lease pays a lease to the revocable living trust, which has the vehicle. Let's say throws it $300 or $400 a month for using it, whatever you decide. So the money goes over there, and then from over there, it goes to the mothership. Because your mother, I call it the mother trust, is the beneficiary of all of those trusts. And that's how you make your trusts pass through entities where the money is literally just passing through. Okay, because the money belongs to the end user. The end user is the one that's responsible for the tax.
And you can do this with all types of assets, like rental properties, anything that you can loan out to people or whatever. That way, your liability is free and clear because that asset is in the trust, and then you rent out or lease out those assets.
Yeah.
And bring in the money.
You can even put in the indenture that if anything happens, or, if nothing happens, the beneficiary could be the mothership, and it could also be like, let's say, your nephew, and then you also put in there that you, the grantor, you can use it, your nephew can use it, and the mothership gets benefit from it too. And it's also able to be leased to this other company which you have a contract with it, the other, business trust. So it's fascinating how all of the trusts, you could go out and design a business trust that, builds widgets. I'll just use that for example. And that widget trust has to rent equipment that's owned by another trust you own. So guess what I'm going to do? I'm taking my computer. I'm taking my really expensive, my copier, and anything of really substantial value, and I'm going to make a trust of all of the office equipment. And I'll throw a beneficiary or two in there. And then I'm going to make a contract where my husband's business leases all of that equipment from my other trust. But when it pays to lease the equipment, it pays the mothership. It doesn't have to pay the little trust. All the money goes to the mothership. You see?
I see, but do you still, you are the creator of the trust. You can't be the beneficiary. So even if you were the mother.
No,
so
I don't want to be a beneficiary on any trust. Do you want to know the position I want to hold? I want to hold just the general manager, and then my husband holds general manager. We're not really interested in being beneficiaries in any trust at all.
So how do you guys? How do you get any benefits?
How do I get any benefit?
Yeah.
Well, let me see. When my husband goes out and creates a contract, his customer is going to pay the business, right?
Mm-hmm.
So the money goes into the business trust account. The business trust account has to pay him to manage the business.
Got it.
You decide what that is. It doesn't have to even be an amount. You can make it a percentage. You could say he gets 85% of all the earnings that come into the trust.
How do you manage
Frankie,
the tax on that piece?
Okay. So the way we manage the tax on that is when he has his contract with the trust, the trust is going to say to him, we don't collect taxes for you. We don't pay taxes for you. It is your responsibility to take care of your own tax,
Sure.
Whatever tax duties you think you have, it is your responsibility to report that. We don't do that for you. Okay, right. He signs the contract. We agree. We're also going to ask him for an affidavit in lieu of a W-9. So I'm not interested. Our trust isn't interested in getting a W-9, but we'll take an affidavit showing, why you're not taxable. Okay, so my husband gives the trust that. We got it in the file. All right, now he gets his little check, right, from the trust.
Yep.
Trust doesn't
I'm
have to
with you.
report to anybody.
Uh-huh.
Okay, now my husband has already sent in his letter of revocation to the IRS
Right. Got
and
it.
basically said
He's not.
all of my earnings, are earnings, and I don't have any income to report. And I haven't had any income to report in the last year, and I won't from here on out. Thank you very much. I'm not participating in the voluntary tax program.
Right.
It's done.
Yeah.
Okay.
Got it.
He goes out, and as general manager of the trust, he hires a contractor to do some work with him on a big house that they have to finish. He's going to tell the contractor, hey, just so you know, we don't do W-9s. We're going to have you fill out an affidavit in lieu of a W-9. But if you feel like you really need something like that to report your taxes, my secretary would be happy to give you a ledger at the end of the year, letting you know how much we paid you. And you can take that and you can stick that in your little tax form where it says other income that's not reported on W-2. That's actually a tax form. And that's where you take it. But, and we're done. The thing with these
Could you also share? Could you also?
be upright.
Did we lose you?
No, I'm here.
Oh, I was gonna say, can you also share that affidavit, a copy of that, so I can see what it looks like? Because I obviously need that for my business. So
Yeah, it's quite a few pages long. Maybe you can direct message me your email, and I'd be happy to show you what we do.
I direct message you already.
Okay, great. So the thing with these trusts is it's express. Just put it down on paper so that it's very clear how you're going to function and how everything works.
Guys, I dropped the file in the chat from the late Christian Walters, 32 gigabytes of trust information with forms and everything. He is essentially
Wow.
a guy that introduced our community to trust and equity when nobody else was teaching it. I was under his tutelage for a while. And
Fantastic.
I had most of his files, and I just shared it with the group. So a lot of the stuff you're talking about, he goes over. There's a lot of recordings and things of that nature to help you in your development of your trust.
Yeah, I will say this.
Thank you.
I've been reading on trust for about 2 years, and I'm just like getting it, getting the indenture created. It's not something you just put together and, run to the bank with. You know what I'm saying? It's it's something you should take a lot of pride in preparing. The way I see it is I'm going through all of this not so that I could benefit, Obviously we have to live and we got to pay bills and we got to buy groceries and do this and that. But I consider this, I want to do this as a legacy to my son and my grandchildren. All these elites and all these wealthy people, they're always looking for ways to extend the family dynasty, the empire, to keep it going forward. It's not so much about reaping from today. You will find ways to benefit from all these assets because guess what? They were yours to begin with. You had possession of them. You chose to give up title, but it doesn't mean that you choose that you're not going to get use of it. You're just giving up control, which is I think it's a really good thing. I think it kind of like relieves us from this need to have and to hold on to stuff. It's very freeing,
Totally agree. Own nothing, control everything.
Right. You know, and when you're controlling it, it's not, you know, with greed in mind. It's controlling it like for the benefit of others. Like,
Yep.
how can I preserve it? How can I, you know, aggrandize it? How can I add to it?
How can I help other
You know,
people?
so that when the next one comes along, yeah, so that when the next person comes along, you know, they don't just have a vehicle, but they've got a really good vehicle with really good tires, or, you know, maybe I retired this one and gave it away and had plenty that I could get another one, you know, for this or for that. So it's, I don't know, it's kind of like this thing of doing business, you know, with a very charitable heart, and also with the idea of constantly planning for the future in a way that's not just shoving money in the bank, you know, putting fiat currency in the bank and thinking that that's going to solve all your problems, you know. But I've talked enough.
Thank you for the input.
Thank you.
Okay, does anybody have anything else? Roberto?
No, that was perfect. That was exactly.
What you're
I
looking
really, yeah, I really appreciate Private Nobody and Prairie Goat Mama's input. I really feel like you guys have a good handle on what I'm like. I think not just my journey, but I think a lot of people's journey, and that really helped a lot. Thank you.
Okay, well, I think we're only going to get through those 2 chapters, but I think we definitely got a lot of information out there. So appreciate it. I'm going to go ahead and stop the recording.